Hi, welcome back. Here we are at week 2. This week we're going to look at legal principles in tort law. There are several things that follow under tort law. I'll address those in just a second. But the remainder of this lecture will deal with unintentional torts. Next week we'll deal with intentional torts. Note this information comes mainly from Wong, Chapter 3. So what are we going to do in this week's lecture? We're going to get a grounds for understanding intentional torts, mainly negligence. We'll understand what it is to bring a claim of negligence, and we'll also be able to address possible defenses for a negligence claim. So, now that we've talked about that we're going to break down tort law, what is it? By definition, tort law is a private or civil wrong or injury suffered by an individual as the result of another person's conduct. All right, let's unpack that. What does that mean? Recall from week 1, we talked about civil versus criminal. Civil law requires a preponderance of evidence. That is, for an individual to be able to bring a tort, they have to be able to show 51% as the burden of proof. This is quite different from our civil law. And remember, in civil law, we have to indicate, in criminal law, we have to indicate guilt beyond a reasonable doubt, or 99%. As I've already stated, in this instance of tort law, then, all issues being brought are civil. In most of these instances, we are not talking about jail time as punishment. Rather, we're discussing the outcome of allocation of money as compensation for loss. There are several causes of actions that fall under tort law. First, as you see on that right-hand portion of the slide, are intentional torts: assault, battery, defamation, invasion of privacy, and infliction of emotional distress. We will spend our entire lecture next week addressing those intentional torts. This week, we are going to stick to unintentional torts or negligence. This slide gives us a big picture window of breaking down torts and tort law. As I already indicated, we're going to spend our time talking about unintentional torts and or negligence this week. Next week, we'll talk about reckless misconduct and those intentional torts. Please note there are 5 areas that fall under intentional torts: assault, battery, defamation, invasion of privacy, and infliction of emotional distress. Use this as a great visual to help you understand the breakdown of torts. When it comes to tort law, the degree of intent is key in understanding where this issue falls. Please recall back to our previous slide. We broke down tort law into 3 sections: unintentional, reckless misconduct, and intentional. For unintentional torts, there's no intent to act and no intent to harm. That's going to make much more sense in the coming slides. With reckless misconduct, there's an intent to act, but there's no intent to harm. You could argue the person just acted recklessly without the intent to harm another individual. In intentional torts, remember there are 5 that fall under this, there is indeed an intent to act and an intent to harm someone else. Keep this in mind because intent is going to help us understand the breakdown of where a situation falls when we begin to classify it under a tort. As I already indicated, we're going to spend the remainder of this lecture talking about unintentional torts or negligence. There's some key concepts that we need to understand, or general terms that will help us make sense of negligence. First, as I already indicated, there's no intent to act and no intent to harm. I want us to think about it this way. There is an injury sustained by someone, but the intent was not to cause harm. And oftentimes we consider it there was a failure to behave or provide caution. It's only applicable to those risks that are or should be apparent. And that's going to make a lot more sense when we talk about these required elements of negligence. In order for a negligence claim to be made, all of these 4 elements must be present. I'm going to help us work through these in the remaining sections. First, there has to be a duty or a standard of care. Second, there has to be a failure to act as a reasonable and prudent person, or there must have been a breach of that duty. Number 3 indicates we had to have causation, and number 4 says we had to have damages. In order for a negligence to occur, all 4 elements must take place. Let's talk about those elements individually in the coming slides. Let's talk about our first element of negligence. Please recall that in order for negligence to occur, all 4 of these elements must happen. The first one is duty, or as we could call it, duty of care. I want you to think about duty of care as this way. What responsibility is owed by one party or person to another party or person? Is there a special relationship that exists between a service provider and an injured person that establishes that the service provider must protect the individual from unreasonable harm or risk? Think about it this way. As a coach, do you have a duty of care to your athlete? That is, do you have an obligation or a requirement to behave in such a way towards your athlete? And as we're going to learn, typically, yes, coaches do indeed have a duty of care. What does that mean? Typically, under negligence, the courts have followed this notion of a reasonable care standard. Okay, how would a reasonable coach act in this situation? How would a reasonable sport facility director act in a similar situation? The reasonable care standard often helps us give way to understand our duty of care principle. It's also very important to note that trained professionals are held to a higher standard when it comes to duty of care. Why? It's believed that trained professionals, for example, maybe a physician, has a high standard of responsibility to care and or a duty of care towards their patient. It's also important to think about this notion of duty to care as a moral obligation or a legal obligation. A legal duty may be based on the fact that the relationship exists between 2 parties. Such relationships, like a coach-athlete or an employee-employer, establish a legal duty to act. There are many relationships that may constitute a moral duty to act, but there's no legal duty. For example, if you're on the street and see someone in distress, do you have a legal duty to care for that individual? Actually, you don't. You may have a moral duty to care for that individual, but you don't necessarily have a legal duty. One thing, though, under the moral obligation standard, if you, by chance, are walking on the street and you see someone fall in distress and you begin care on that individual, because you began care, you now are legally obligated to continue to give care. And that may be that you simply sit by and call 911 and stay with that individual until professionals arrived. Okay, our first element then is duty of care. And in order to establish this duty of care, there has to be a relationship that exists between 2 parties. It's that general duty to care for and govern the activities. It's also based upon the reasonable care standard. Let's look at our second element. Let's talk a bit more about duty to care. In the world of sport and with sport management professionals, oftentimes facility owners are held to a very high standard. Whether that's a facility owner of a professional stadium or a facility owner of a batting cage. Therefore, it's important to determine the status of the person injured in relationship to the facility and the facility owner. The courts have repeatedly ruled if there is a trespasser or someone who enters a facility without permission, the owner of the facility does not have to warn of any apparent risks. There is one caveat there. This does not include minors. Please note that. Listed under your trespasser. Okay, our second component Is it a licensee? Does this individual enter a facility, again, whether it's a batting cage or a professional ballpark? Did they enter another's property with the owner's permission for his or her own purposes? If this instance is, for example, if an organization wants to rent out a portion of, we'll say, Minute Maid Park for a special social event, that individual indeed does have the permission of the of the facility owner, therefore they're a licensee. The owner of the property, in our instance, Minute Maid Park, is only owes a duty when the risk is known. The owner is not obligated, particularly Minute Maid Park, to inspect for unknown damages and warn of obvious conditions. Okay, last. This is the instance where we have an invitee. In our example of Minute Maid Park, or maybe even our batting cage, this is the person that pays to use the property. If you're a client of a private batting cage and you indeed pay to use that property, you're an invitee. Therefore, you are owed a greater degree of care. And in this instance, then, owners of that facility, in our example, the batting cage, are obligated to make sure that facility is safe and without any obvious defect. Okay. This gives us some more layers to understanding what does a duty of care look like. I have one more piece of that. One other major component under duty of care is standard of care. We talked about that at length when we brought our first slide out regarding duty of care. So what is this notion of standard of care, and how indeed do we determine that standard of care? First, one of the ways we determine it is by case precedent. We're under a common law system. What has those cases prior stated that would help us determine what is the standard of care? We also have legislation, and we have rules and regulations. So, for example, rules and regulations help us understand that the standard of care might be expressed in written form by an organization. So, for example, if you're a coach and you work for a specific organization, does that organization have rules that govern maybe tackling in football or fighting in hockey, or the number of lifeguards required by the pool? If so, that's the standard of care you should give. Also, a couple things to think about. What's the community standard or practice? So, for example, if we're back to a pool facility, what's the community standard or practice in dealing with poor weather or lightning in the community? A couple of other concepts to consider. Professional associations. For example, what does the American Academy of Sports Medicine say? What does the NCAA say? If those are the standard of the professional associations, then that's likely a standard of care that should have been given. Expert testimony and expert opinion also gives us some information about standard of care. All in all, it is the responsibility oftentimes of the party involved to ensure they have followed appropriate procedures in place to ensure that they're meeting standard of care. And ultimately, if a negligence case is brought, one of the ways that we can determine that standard of care must be given is through this list of information. Now that we've established our first element of negligence as duty of care, let's make note of our second element, breach of duty owed. That is, did the party that owed a duty of care, did they break that or breach that duty? There's 3 burdens of proof to indicate that the duty was indeed breached. First, there's this notion of direct evidence of negligence. Negligence is established through proof of the actual occurrence. Second is negligence per se. That is, one of the parties was in violation of rules or regulations. They might have been in violation of state and federal law, or maybe they were simply in violation of agency policies. Those are all violations per se negligence per se, and upon finding a violation of this statute, there's an inherent or an inference of negligence. Last, and the third burden of proof is this notion of the thing speaks for itself. This allows the plaintiff to establish the more likely than not the harm to the plaintiff was a result of negligence. These requirements must be met. There's three of them. The event ordinarily does not occur except through negligence. 2, also must demonstrate that the instrument that caused the injury was in the exclusive control of the defendant. And 3, the described injury was not a result of the plaintiff's own actions. The thing speaks for itself. Okay, that gets us through our second element of negligence. We've established that in order to show negligence, we must have show a duty of care, and second, we must have shown that that breach of duty was owed. We've now made our way to our third component, actual and proximate causation. Recall our first two elements of negligence were duty of care and breach of duty. This is now going to establish what was the cause of the injury. First, I want to talk about that bottom portion of our slide, the but-for test. This is what we can think about cause and fact. The defendant's breach of duty was the factual cause, or maybe even cause and fact, of the plaintiff's harm. Courts have established this but-for tool, or but-for rule. This causation requires a finding that but for the defendant's conduct, the plaintiff would not have been hurt. Then there's proximate cause. This is where the plaintiff must establish that the defendant's negligence was the proximate cause of injury. A couple of ways to think about that more clearly is, did the defendant or should the defendant have foreseen this injury? Or they should have foreseen that there was a probable or natural result of negligence, and that is what caused the injury. This is also to indicate in a proximate cause, a person of ordinary caution and prudence could have foreseen or likely prevented the injury. Okay, that gets us to the end of our third element. We have duty to care, breach of duty, and actual and proximate causation. We've arrived at our fourth and final element of negligence. This is damages. For a negligence cause of action to hold, some actual harm or injury must exist. Repayment of damages is classified in two ways. First is compensatory damages. Compensatory damages are to compensate the individual for loss. We can see that on the right-hand side. That loss can come from economic loss, physical pain, or mental distress. Damages can also come in punitive damages. The purpose of punitive damages is to punish the defendant for their behavior and set an example for other wrongdoers. Two ways to think about this then. The individual can be compensated for their loss, and that can be loss of work, it can be their medical bills, it can be their mental health bills. And so therefore that's compensatory damages. The individual or the plaintiff is compensated. On the other token, the defendant can be punished, and those damages are punitive, and they are done to prove or show, rather, or set an example for others on how they ought to behave. Okay, we've hit all four components of negligence: duty, breach of duty, causation, and damages. In order for a negligence claim to occur, we have to have all four elements. We're going to move on now and talk about the potential defenses to a negligence claim. There are potentially 6 ways that we can defend against negligence. We're going to spend time over the next several slides going through each of these individually. First, there can be no negligence. There can be contributory negligence, comparative negligence. There might have been an assumption of risk. Maybe the statute of limitations has run out, or maybe there was immunity and Good Samaritan statutes. We'll talk about those coming up. We're going to address those 6 defenses for negligence. Our first one is no negligence. What does that mean? The defense is able to show that one of the 4 previous elements we have been talking about was indeed not present. So 2 ways to show this is by attacking one of those 4 previous elements, as well as specifically showing that the defendant did indeed give reasonable care. The second defense is contributory negligence. Only Alabama, Maryland, North Carolina, and the state of Virginia have contributory negligence. The remaining 46 states have comparative negligence. We'll talk about that in the next slide. Okay, so what is contributory negligence? In this instance, if there was any negligence on the part of the plaintiff, this precludes the plaintiff from receiving damages. This considers this idea that the plaintiff partially contributed to the negligence. In this instance, the plaintiff, again, is partially responsible for negligent behavior. Our third defense for negligence is comparative negligence. Obviously, in the previous slide, we talked about contributory negligence for those 4 specific states. The remaining 46 states in the Union follow and/or abide by comparative negligence. This notion is a method of apportioning the blame. This method could provide potential recovery to the plaintiff, but only for the apportioned fault. Okay, let's make sense of this. If the plaintiff's blame in the negligence is 50%, they don't receive any recovery. However, if the plaintiff's blame was only 20% in the negligence claim, they indeed will receive recovery. The fourth defense of negligence is assumption of risk. We see this very, very commonly in the world of sport and as well as those attending sport. The assumption of risk is this notion that a defense by which a plaintiff may not recover injury in negligence when they have voluntarily exposed themselves to and know the appreciated dangers. There's 3 specific elements we can talk about with assumption of risks. The risk might be inherent to sport. The participant might have voluntarily consented to be exposed to the risks, and the participant must know, understand, and appreciate the inherent risks of the activity. It's also important to note that these inherent risks can't be removed from the activity without altering the activity in and of itself. And those individuals have voluntarily consented to take on the risk. There's also been a knowledge, understanding, and appreciation. And through that, we express and imply assumption of risk. Okay, let's make sense of this assumption of risk component. Individuals who decide to partake in a marathon assume some risk when taking part. And oftentimes they express consent in doing so. They do so often in writing in order to be able to compete or run in, we'll say, the marathon. It's also important to know, though, when we imply this assumption of risk, it does not cover claims of product liability, nor does it allow individuals to behave in negligent fashions. The applied assumption of risk presumes that the individual has voluntarily participated in an activity and it involves a well-known risk. If these risks are unforeseeable, it might be negligence. Our 5th and 6th forms of defense against negligence fall under statute of limitations and immunity and Good Samaritan statutes. Statute of limitations simply indicates that the individual bringing the negligence claim has not done so in a timely fashion or the time period at which the law requires. Our number 6th reason is this notion of immunity and Good Samaritan statutes. There are some or defense may be offered on a defendant based upon the position of the defendant, not the action of the defendant. That is, by the position of the defendant, they might be immune to negligence claims. Also, we have the Good Samaritan statutes. This protects individuals who seek to render aid to those in distress. So, for example, if you are on the street and you see someone in distress and you render aid to the best possible way that you can, you're protected from potentially harming that individual by the Good Samaritan statute. This is put into place to ensure we indeed do render aid and do help those who might be in need. Okay, here we are. We've made it to the end of our unintentional torts. Remember, with unintentional torts, it's important to note there was no intent to harm. People behaved negligently. And in this, we've determined there are 4 ways that we have to show, or 4 elements rather, that negligence does occur. We've also provided 6 defenses for negligence. If one was going to counter a negligence claim, these are the 6 potential defenses for that claim. This is going to conclude our unintentional torts. Next week, we'll go on and talk about these intentional torts, those that not only have an intent to act, but an intent to harm. Have a good week. We'll see you next week.